Hold on. I have on heads. Morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what is called an arraignment. The arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into two categories. They are divided into felonies or misdemeanors. Your felonies are cases that are normally referred to as your most serious type offenses, whereas your misdemeanor offenses are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I mean is I'm talking about the facts of the case, and I'm also talking about the possible punishment that a person can receive if they are convicted of the offense. If a person is convicted of a felony offense, first of all, there are 5 categories of felonies. We'll start at the top and work our way on down to the bottom. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. Sir, would you please be quiet? The second category is a third-degree felony. The third-degree felony range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, the case that you have in this court is a misdemeanor case, so you won't have to worry about that type of punishment. Now, misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor. We start at the top. the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, those are cases that are normally handled in the JP court, the Justice Court, or the municipal court, which is the city court. For example, there are offenses like not having your seatbelt on, speeding, not having a proper inspection sticker, or having an expired inspection sticker, etc. So if you're convicted of a Class C misdemeanor, the range of punishment is fine only, cannot be given any jail time, and the fine cannot exceed $500. However, if you fail to pay the fine, or if your fine was converted to community service and you failed to pay the community service or perform the community service, then the court can issue what is called a capias pro fine. A capias pro fine simply means that it is a warrant for your arrest to serve out your time in jail. So, for example, if a person failed to pay a $200 fine, they could be issued a capias pro fine, arrested, placed in jail, and they'll sit in jail until that fine is set out. You receive $100 per day for every day that you sit in jail. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to maximum of 180 days in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation that a person can get. One type of probation is called adjudicated probation. Adjudicated probation means that you will have a conviction on your record as soon as you're placed on probation. However, there's something that is called judicial clemency. Judicial clemency means that the judge or the court can set aside your conviction, and you will no longer have a conviction if these three things happen. One, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged or let off the probation. If those three things happen, then the court has the discretion to set aside your conviction, and you would no longer have a conviction for that case. However, if you get a subsequent conviction, another case later on, then this case that you received judicial clemency on can be resurrected, revived, or brought back up, and it can be used against you in any subsequent case. The other type of probation is called unadjudicated probation. Unadjudicated probation simply means that you will not have a conviction when you get placed on probation. You'll be on probation, it's not a conviction. And if you successfully complete the probation, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that your record is sealed to the general public. And as I use the term general public, what that means is the general public cannot have access. However, the government can have access, the police department, schools, universities, municipalities, any government or agency can have access, but most of the public is the general public. They're not the government. So most of the public will not have access to to that case, because it will be sealed to them if you qualify. Now, as a defendant in a criminal case, you have rights. One of the rights that I'm going to go over is your right to have an attorney. There's clipboards that are in the gallery. Everyone should have a clipboard. On that clipboard, the first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. That document talks about your right to have an attorney. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire your attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, you can represent yourself if you waive your right to have an attorney, or if you give up your right to have an attorney to represent you. This document further states that if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date. And the reason why you'll be given another court date is to give you time to hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. The financial questionnaire is a third document on the clipboard that is titled Jefferson County Affidavit of Indigence. You will have to fill out the first page and half of the second page so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, that is, you want to waive your right to an attorney and represent yourself, you'll have the opportunity to talk to one of the two prosecutors that are here in court, that are sitting at the table before you. You may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver should be the second document on the clipboard. It is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You would have to read and sign that document, and we're going to go over that. I'm going to go over that document with you in about 2 minutes. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you decide to represent yourself or waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will have to place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney, to give up your right to have an attorney to represent you, and you want to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign at the bottom of that document on the line that is titled Defendant, and you will date it today's date, April 16th of 2024. Now, for those individuals who will be waiving their right to an attorney and representing themselves, you will have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it reads as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. Voluntarily means that nobody is forcing you to sign this waiver. You're doing it of your own free will. And it says, and intelligently made. Intelligently means you know what you're doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 16th day of April of 2024 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, April 16th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. When those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence, all the arguments, and they will deliberate, and then they will decide whether to find you not guilty or guilty. You also have a right to waive your right to have a jury trial. That is, you have a right to give up your right to have a jury trial. And if you waive or give up your right to have a jury trial, your case will come before the court in one of 3 ways. One way it will come before the court is by way of a trial. The trial that it will come before the court is called a bench trial. A bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments, and then the judge will decide whether or not you're guilty or innocent based on the law and the evidence that is presented. You also have a right to waive or give up your right to have a bench trial. And if you do so, the second way that your case will come before the judge is by way of an agreed plea bargain. It will come before the judge by way of a plea bargain. Plea bargains are divided into 2 categories. You could have an agreed plea bargain, which means you and the state have reached an agreement to settle your case. That's what a plea bargain is. You and the state are negotiating to settle your case. If you come to an agreement, we call it an agreed plea bargain. If you do not come to an agreement, then we call that an unagreed plea bargain agreement. Now, if you have not been able to reach a plea bargain agreement with the state, then your case will come before the court, and the court will decide what the punishment will be in your case. If you are able to reach a plea bargain agreement with the state, the third way your case will come before the judge is by way of an agreed plea bargain. And once it comes before the judge has 2 options. The judge could either accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, then you can withdraw your plea. That is, you can take back your plea of either guilty or no contest. For example, let's say you and the state has reached a plea bargain agreement for you to serve, let's say, 1 day in jail. And it comes before the court, and the court said, well, I'm not going to follow that plea bargain agreement. I'm going to reject that plea bargain agreement. And you can tell the judge, well, judge, I withdraw or I take back my plea. In essence, I'm not pleading guilty or I'm not pleading no contest. since you are rejecting the plea bargain agreement, you have a right to do that. Now, if the judge does accept the plea bargain agreement, then and if you decide within 30 days that you would like to appeal your case, and appeal your case is you would like to have a higher court to look at your case to see whether or not you've been wrongfully convicted or the court committed an error by convicting you. And so if you would like to appeal your case after the judge follows the plea bargain agreement, you have to get permission from the judge. If the judge gives you permission to appeal your case, then your case will go to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case. They could either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas, and you would have to file what is called a pro se petition for discretionary review. Pro se means that you are representing yourself. You won't have a lawyer. You'll be handling this petition on your own, and you'll be petitioning the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, or whether or not you was wrongfully convicted, or this court committed an error by convicting you. The Court of Criminal Appeals could do one of two things. They could either grant your petition or deny your petition. If they grant your petition, they could simply find you not guilty, or they could send the case back to the Ninth Court of Appeals, or they could send the case back to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have what is called discovery. Well, you have a right to have witnesses to come to your case and testify. Witnesses sit in that chair over there to my left that has the microphone in front of it. That chair or that area is called the witness stand. And what witnesses do, they testify. They can testify for you or against you. If you're representing yourself or if you have a lawyer representing you, you can ask some questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses. If you waive or give up your right to have witnesses, what that means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. You also have a right to you also have a Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify in your case. State of Texas, the government, prosecution cannot force you to testify in your case if you exercise your Fifth Amendment right against self-incrimination. Now, I know a lot of us watch television, and you see people on television on these law shows say, I take the Fifth. And what that means is I ain't saying nothing. Okay. And so you have a right not to say anything in your case. Okay. Then we call that the Fifth Amendment right against self-incrimination. Now you can waive it, which means you can give it up. And if you waive it or give it up, that simply means that you will be making a statement or you will be testifying in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence or have access to the evidence that the state has against you, or to discover what the state has in its file. You also, and that means that you have a right to see, have access to your statement if you made a statement, witness statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings. You have a right to have access to any instrument or whatever evidence that they have. We call that discovery. Now, you also have a right to waive or give up your right to have discovery. And by doing so, you will not be having access to the evidence that the state has and will be using against you. Everyone that's here today, that's here on our docket for a case, you have been arrested. You were in jail and you're out of jail now on bond. You're either out on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out on surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you are out of jail on what we call a personal recognizance or a PR bond, which means that you didn't pay any money to get out of jail. You were released under your own personal recognizance. Now, I said that to say this. Every day that you spent in jail, that can be used as credit towards your punishment. Now, when I use the term day, if you spend 1 second in jail, you spend 1 second in jail and bonded out, that's considered 1 day. Or let's say you booked in jail at 11:59 p.m. and you got out of jail 2 minutes later at 12:01 p.m. That's 2 days in jail. Okay, it's 2 different days. So that's how they look at it. So every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail and then you bonded out. You and the state have talked, y'all reached an agreement for you to serve 5 days in jail. That means you won't have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you spent 5 days in jail, that means you only have to spend 2 days in jail because we're going to take 5 days from the 7, at least 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. You will receive $100 credit per day that goes toward your fine and court costs. So in the example that I used earlier, if you spent 5 days in jail, that's $500 credit that will go toward your fine and court costs. So if you and the state have reached an agreement, and the agreement is to pay fine and court costs of $500, that means you won't have to pay anything. Why? Because you have $500 credit for the 5 days that you spent in jail. Now, if they're offering $700 fine and court costs, and you spent 5 days in jail, that means that you have to pay $200 because you already have $500 toward the 7. So we take the 5 from the 7, that leaves 2. Now, you'll be required to pay the fine and court costs on the day that you dispose of your case. Now, if you are unable to pay the fine and court costs, well, we can convert the fine and court costs to community service. Every 1 hour of community service that you perform at a nonprofit organization, $12.50 will go toward your fine and court costs. So for example, if you work 8 hours of community service, that's $100 that will go toward your fine and court costs. So in the scenario that I gave earlier, if a person owes $200, that means if they work 2 8-hour days, that's $200, and then the fine and court costs is paid off. Now, Jefferson County has a program for people who have not been in trouble before. If you're a first-time offender, Jefferson County has a program where they will dismiss your case. And if you successfully complete the program, you can get it expunged from your record. That means erased, wiped off, or deleted from your criminal record. The program is called pretrial diversion. And in order to qualify, as I mentioned earlier, it has to be your first time getting into trouble. You have to have an attorney to help you to make that, to submit the application to the district attorney's office. And it cannot be an offense for resisting arrest or unlawfully carrying a weapon. Now, if you do qualify, as I mentioned earlier, the case will be dismissed. You complete the program, and you can get this expunged, wiped off, deleted, or erased from your criminal record. It's just like it never happened. Okay. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. Veterans Court is a program for veterans only. With that program, which is part of the pretrial diversion program, if you're accepted into the program and complete the program, your case will be dismissed, and you can get what is called a non-disclosure. That means that your record will be sealed to the general public. The only qualification is that you are a veteran of any one of the branches of the United States military. This court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. And with that program, the program is designed to address the issue of recidivism. Recidivism means people commit crimes over and over. And so how do we address the issue of recidivism? Well, we address it through the Community Safety Initiative. And through that CSI program, we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our regional mental health center in the Jefferson County or the Southeast Texas area. And basically, we'll have some folks from Spindletop that's going to come and tell you a little bit more about the program that Spindletop has to offer. But basically, Spindletop they have the ability to do private interviews, either here or at their facility or by phone, whichever is convenient for you. And they also have the ability to do an assessment, develop a treatment plan, either for outpatient or inpatient services. Spindletop also has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. It's a drug and alcohol recovery program. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. Both ATAR and OZAR are drug and alcohol recovery programs. What they will do is they will have a private screening. Then they will do an assessment, and they can develop a treatment plan for you, either for outpatient or inpatient, depending on your drug and alcohol needs. If you're unemployed and do not have a job, or you are employed looking for a better job, well, we have a partnership with our Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that you select, they will assist you at getting a job in the area that you're trained in. If you have not finished high school, you do not have your high school diploma, well, CICE has a GED program which you can get your graduate equivalency diploma. All of these programs that I just mentioned to you will not cost you anything because they're free. Actually, the only thing it will cost you is time. And in this court, I like to say that we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. We believe that if we address the problem, we can produce productive people. If we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And if we make a difference in the lives of the individuals that comes before this court, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So this program is called the Community Safety Initiative. And the other thing about this program is all of these programs that I just mentioned can be used as community service. So let's say you cannot pay your fine and court costs, and we converted it to community service. And let's say you're in drug treatment. Every 1 hour you're in drug treatment, $12.50 is going toward your fine and court costs. 1 hour is going toward the community service, and you're participating in the program. The same thing holds true if you're in mental health treatment with Spindletop. For 1 hour of counseling, $12.50 is going toward the fine and court costs. 1 hour is going toward the community service, and you're in the program. So I tell people this all the time. You're not killing 2 birds with 1 stone, you're killing 3 birds with 1 stone. Because you're in the program, you're doing community service, and you're paying your fine and court costs. And so if you're interested in any one of these programs, just let us know, because we can point you in the right direction. We have brochures that we can give to you that can assist you at informing you as to what the programs are all about. And it will place you in contact with the people that you need to be in contact with to get into the program. Okay? So if you're interested in any one of these programs, just let us know, and we'll be happy to get you involved in this program. Now, as I mentioned earlier, we have some folks from Spindletop who's going to come to you and tell you more about the program or programs that Spindletop has to offer. At this time, we have Chris and Deputy Hinton. They're going to come forward.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy acting by the State Commission here at the Sheriff's Department. This is Chris. Now, Chris is a qualified mental health professional in Spindletop. The reason we are both here this morning in this courtroom is because the judge cares about every single person that comes before the bench. The judge found, which is proved, as though we have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with a particular situation.
The reason mental health needs means things like anxiety and depression, especially with judgment stuff, things that occur for everybody at some point in their lives, and that being involved in the judicial system does not necessarily make it easy. Now, whenever we're talking about community resources, I know that inpatient, outpatient, it's not that we can get information for any of those. But the big thing is that there's a lot of really great community resources, not just here, but in Texas in general, that are well funded, but they're not well advertised, and sometimes even just finding the name for them is a bit like jumping into. And that's kind of what we've done. We're here to keep moving conditions, we're here to provide support. We're here to be an ear, because I know that there's a lot of times that this is a wholly independent situation that's hard to describe to people. It's hard to talk to people about. We're here to make sure we can help.
So maybe this is your first time to be here or your 10th time to be here, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us so we can best determine how to advocate, how to help you, get you connected to the resources that will fit your particular situation. And Chris is going to explain exactly how you can do that very privately.
So whenever you guys came in, on each of the clipboards, there was this form. This is our resource sheet. This is built like a baseline of the consent form. And so this is all to everybody. I see some people in here as support. I see that, maybe you don't have information for yourself, maybe you need information for somebody you care about. It doesn't matter. If you don't have one of these sheets, I'll walk around and make sure everybody does. This is created this way so you know that any information you put on here is protected under state law. It will not be shared without your permission. The only one who's gonna see it is me. The only one who's gonna contact you is me. I'm gonna contact you in the minute you're choosing or speak with me privately if you want to. I know the board sometimes moves fast. If you put yes down here at the bottom and you want to speak privately, just fine. If you can't, if it gets to the point where you have to leave, just let me know. I mean, it can still call you today, okay? But outside of that, you will hear from me tomorrow. Whatever way you want. If you don't answer, it's gonna be a real tough situation where I sit there and blow the phone up. I know that no one in here has anything. What this is gonna be is I'm gonna call you once, or text you once, or email you once, whatever you choose. And then you will have my contact information, or we can call. I understand that all of you guys are up here today. I'm sure there's plenty of games that were called outside that didn't walk in your clothing. You all made an effort, you all here, we know you work hard for yourself. You want to match that. It doesn't matter, like, there's no time limit or cost or anything associated with this. This is just as long as you reach back out to me, I will keep reaching back out to you. I promise this is just, we're here to look for, right? We're here to make sure that this one is productive, and also not a situation anybody wants to be in or see somebody take care of it. And we can use it. It should have not been before, it should have been something that you guys met out in the community. Where we can really do it now we want to. So if you have anything you want to talk about, or you just want to, or you have anything, or there's anxiety, or there's panic, or there's anything coming up, we're here. That is the one reason we're here. And it's just, we're here for you.
I also have this flyer that I want to get in everyone's hands before you leave here today. On the back, it tells you some of the advantages of participating. But also on the front, it has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help you need.
That's important because that is the first resource we give you. It is a crisis number. It is 24/7. Outside of that, it is active almost statewide. You understand a lot of people come to Jefferson County or to court in Jefferson County and not anywhere close to here, right? We have people like us from Oklahoma. It doesn't matter where you're from. If you have something you need, we will help you do the things. You need help, we're here. That number, as I said, almost statewide. You know, there's a lot of places in Texas where no phones work, no matter what we do. But it's 24/7. You can call the weekend on Christmas Day and never pick up. If it's not a crisis, if it's just, if you have something you need, please reach out to us, please let us know. But we have the other resources like that to make sure that you have what you need in whatever moment that arises, because a lot of times it's just making sure that the tool is there, right?
So just shortly, the court is going to go into recess. When it does, we'll come out there, we'll pick up those documents from you. I'll be handing this out to everyone as well. We'll answer any questions you have at that time, and we will work around the parameters of the court proceedings and don't delay.
Also, if you have a time that works best for me to reach out to you, if there's a certain time of day when you are free, please put down a sheet. I'll do my best on it, and I'm not trying to interrupt or cause any issues in y'all's lives either, because I know that it's important.
Thank you, Your Honor.
Thank you, Chris and Deputy Henry. Okay, ladies and gentlemen, we're going to go into recess in a few minutes, but before we go into recess, I need to just give you some housekeeping measures. Now, the paperwork that you have on the clipboard, if you need any assistance at filling out that paperwork, then we have our court personnel who will be here to assist you with filling out the paperwork. It's going to take us a few minutes to gather all the paperwork to make sure that everything is signed properly. And then if you need to use the restroom, there are 2 restrooms right outside the courtroom in the hall. The men's restroom is right next door in front of County Court at Law number 3. And the women's restroom is on the opposite side of the hall in front of the 179th District Court. Now, please do not leave the courthouse. If you leave the courthouse and if your name is called and you do not answer, then your bond can be forfeited. And if your bond is forfeited, a warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Now, as I mentioned earlier, this is gonna take us some time to make sure that all of the applications are filled out properly. And then we're gonna call you up before the bench, one at a time. And then, you'll be put into one of three categories. And then once we finish with your case, the court coordinator will give you a reset, case will be reset, and then you'll be free to go. So at this time, the folks from Spindletop, Deputy Hinton and Chris, they're going to come out. And if you, to make sure that those applications that they passed out are filled out properly. Now, at this time, we're going to go into recess. Jefferson County Court at Law number 2 is back in session. The court is in session with its arraignment docket on today's date of April 16, 2024. The court is in session with two cases. First case is cause number 24CCCR 0146 and cause number 24CCCR 0331. Both cases are styled the state of Texas versus Terrence Jermaine Carrington Jr. Mr. Carrington, would you please come forward? Carrington. Bill, if you could show him what a stand. Come on up. Okay. Mr. Carrington, is your full name Terrence Jermaine Carrington Jr.? Mr. Carrington, would you please raise your right hand? Mr. Carrington, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Carrington, you may put your hand down. How are you doing, Mr. Carrington? You doing good? I'm doing good. Thanks for asking. Mr. Carrington, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Carrington, before you signed and initialed these documents, did you read the documents? Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Carrington, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lindsay Scott. Attorney Scott will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title? Okay, I'm going to go over this document with you, and it reads as follows. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test in the case the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Texas Penal Code, actively engaged in employment as a full-time, sworn, paid employee of a state agency or political subdivision. Do you understand that condition?
Sure.
Now, Mr. Carrington, if you violate any one of these conditions, your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay. Now, Mr. Carrington, you're going to stand in front of the court coordinator, follow her directions. Once you finish following her directions, you'll just have a seat at that first chair on the wall. Once you finish following her directions, you'll be free to go and you have a blessed day. Next case is cause number 23CCCR 1746. Case is style of state of Texas versus Elijah Papillon Mitchell. Please come forward. Mr. Mitchell, your full name is Elijah Papillon Mitchell.
Yes, sir.
Mr. Mitchell, would you please raise your right hand? Mr. Mitchell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Mitchell, you may put your hand down. How are you doing, Mr. Mitchell?
I'm hanging in there.
Okay, hang on, don't hang up. All right, now, Mr. Mitchell, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that states you'd like to apply for
Yes.
court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? Speak up.
Yes, sir.
And on page 2 of this same document, there is a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Mitchell, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, I do.
And is everything in these documents true and correct
That's correct.
to the best of your knowledge?
Yes, sir.
Okay, Mr. Mitchell, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Next case is cause number 23CCCR 1620. Case to style the state of Texas versus Samuel Zamarripa. Mr. Zamarripa, your full name is Samuel Zamarripa?
Yes, sir.
Mr. Zamarripa, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Zamarripa?
Good, sir. How are you?
I'm doing fine, thanks for asking. Mr. Zamarripa, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that states you would like to apply for court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Zamarripa, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat on that third chair on the wall.
Okay.
Next case is cause number 23CCCR 1616. Case is style of state of Texas versus Robert Ray Freeman. Freeman, would you please come forward? Mr. Freeman, your full name is Robert Ray Freeman.
Yes, sir.
Mr. Freeman, would you please raise your right hand? Mr. Freeman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Freeman, you may put your hand down. How are you doing, Mr. Freeman?
Okay.
That's good. Now, Mr. Freeman, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you would like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Mr. Freeman, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct?
Yes, sir.
And is everything in these documents true and correct?
Yes, sir.
To the best of your knowledge? Okay, Mr. Freeman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Langston Adams.
Thank you, ma'am.
Yes. He's in Port Arthur. That's where you're from. So he has an office in Port Arthur. Mr. Adams will be given information to contact you, and you will also be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Next case is cause number 23CCCR 1646. Case is styled the state of Texas versus Sharik Tajon Kyler. Mr. Kyler, your full name is Sharik Tajon Kyler.
Yes, sir.
Mr. Kyler, would you please raise your right hand? Mr. Kyler, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Kyler, you may put your hand down. How are you doing, Mr. Kyler? I'm doing fine, thanks for asking. Mr. Kyler, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Mr. Kyler, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Kyle, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will also be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. And Mr. Carla, just have a seat in that first chair on the wall.
Thank you. Your information.
That door is closed, so you gotta go through that door. Yellow door. Next case is cause number 23 CCCR 1582. Case is style of state of Texas versus Catherine Maria Jones. Miss Jones, your full name is Catherine Maria Jones?
Yes.
Ms. Jones, would you please raise your right hand? Ms. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Jones, you may put your hand down. How are you doing, Ms. Jones?
Pretty good.
That's good. Ms. Jones, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah,
And is this your signature on the line that's titled Defendant?
right. Um,
Is that your signature on the line that is
Yeah.
titled Defendant? And are those your initials on the line that is titled, that states you'd like to apply for a court-appointed attorney?
Yeah.
Okay, I handle this document too. The next document that's being handed to you is titled Jefferson County Affidavit of Indigence. Do you recognize that document?
Yes, sir.
On page 2 of that same document, there's a signature above the line, is at the top of the document to the left, excuse me, that is titled Defendant's Signature. Is that your signature?
Yes.
Now, Ms. Jones, before you sign and initial the documents that have just been shown to you, did you read the documents? Did you understand what you read? And is everything in those documents true and correct to the best of your knowledge? Ms. Jones, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that would be appointed to represent you in this case is Attorney Thomas Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that fifth chair on the wall.
Thank you.
Just have a seat in the fifth chair on the wall. No, on the wall, next to that gentleman, a seat down from the gentleman right there, yes. Next case, is that two cases? Yeah, next two cases are cause number 23 CCCR 1720, case of style of state of Texas versus Lindsay Danielle Postert. Would you please come forward? Okay, Ms. Lindsay, is your last name pronounced Postert? Okay. Ms. Postert, would you please raise your right hand? Ms. Postert, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Postert, you may put your hand down. How are you doing, Ms. Postert?
Well,
You doing well? And I'm doing fine. Thanks for asking. Ms. Postert, I have before me two documents. First document is titled
this is your part.
Judge's explanation of rights to defendants without attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Okay. Ms. Poston, I also have another document before me. This document is titled Jefferson County Affidavit of Indigence. And do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled defendant. Is this your signature? Ms. Poster, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Ms. Posted, I was looking at your document. What I'm going to do, get off of YouTube. Because the reason why there may be some there may be a disclosure of non-public information. So this hearing, this portion of the hearing will be closed pursuant to Article 1.24 of the Texas Code of Criminal Procedure that states that all trials and hearings shall be public. However, pursuant to the case of Lilly versus State 365 Southwest 3rd 321, the right to public trial is not absolute and may be outweighed by other competing interests, such as interest in security, disclosure of non-public information, and to ensure that the defendant gets a fair trial. And the court is going to make these findings that the party seeking to the closure of this hearing has advanced an overriding interest that will be prejudicial to the defendant in that it will be in that non-public information will be disclosed. And this request is no broader than necessary to protect the interests of the defendant. The court has considered other reasonable alternatives, and the court make these findings, and these findings are adequate for the closure